Welcome, everyone, to tonight's constitutional conversation. This is a series that the Constitutional Law Center puts on to bring in leading scholars and lawyers and people doing and writing interesting things in the broad field of constitutional law for presentation of what they've been thinking about, and then a chance for conversation afterwards. And tonight it is my great pleasure to welcome Professor Mark Tushnet from Harvard Law School. He's the William Nelson Cromwell Professor, but now I guess emeritus. Is that right? Yep. I hadn't realized that. Mark has been a leading figure in constitutional theory longer than I can remember. When I first entered this business many years ago, he was already a towering figure, at that time best known as a leading figure of the critical legal studies movement, and since then continues to churn out books and articles and provocative arguments on all kinds of things. And tonight he's going to be talking about judicial judgment and interpretation, based, I think, on a book that is going to be coming out this coming spring. So with that, please join me in welcoming Mark Tushnet.
Thanks, Michael, and thanks for inviting me out here. As Michael said, this talk is based on the first chapter of a book that's going to be published in the spring with the title of this talk, Who Am I to Judge? Obviously taken from Pope Francis's comments, and with the subtitle that you have out there. I say my preliminary observation is that this is the first time I've given a talk based on the book, and although some people have read it, and turns out that Charles Freed and Justice Breyer liked the book, and my longtime intellectual collaborator, Mike Seidman, hates it. So either I've gone over to the dark side, or I've written something that has something to offend everybody in it, or maybe it's right. And so we'll see as it turns out. So the structure of the argument is that a lot of discussion these days occur when there's a Supreme Court nomination. Takes the form of talking about constitutional theory in general and originalism more specifically. So Senator Grassley asked Amy Coney Barrett a question during her nominations: what is originalism? The reporter who reported this called this a softball question, and it certainly was. And she gave a perfectly acceptable answer, and Senator Sass voted against Ketanji Brown Jackson, saying at every turn she not only refused to claim originalism as her judicial philosophy, she refused to claim any judicial philosophy at all. And those comments, I think, reflect, they're politically driven, and I can't criticize them for the political judgments that they're making, but they do reflect a sense that both politically, and again, I'm not criticizing them for that, but also for us as citizens, we ought to think about potential nominees by focusing on constitutional theory. And the argument of the book is that's wrong, that what we should focus on are what I'll call just summary good judgment or reasoned judgment, and there are markers that we can look for that, which I will summarize as intellectual curiosity and wide exposure to human experience. I just do want to say one thing about the rest of the book, which is about why the search for constitutional theory is misguided. Now, a lot of that is what I say is familiar. I think I make some new points in it, But the point of the search for constitutional theory is to figure out some way that we can live together with each other, even though we know that we disagree quite substantially about matters of substantive policy. And the thought is that we could set up a constitutional system that will generate policies that are defensible in terms of a constitutional order that is justified by what I'm calling constitutional theory. The problem is, I think, that we've been looking for such a constitutional theory for a long time. There are a lot of candidates for them, and none of them seem to work well enough for a variety of reasons that I go into in the book and I can talk about in the conversation. But the question then is, if we're living in this kind of world of conflict, how can we figure out how to run a constitutional system if we don't have agreement on constitutional theory? And so for generations, I think maybe until sort of like the 1960s, 1970s, there was a more or less obvious answer, which was that we would solve these problems by recourse to law. Law understood as something influenced but not determined by policy preferences, incorporating aspects of different constitutional theories to the extent appropriate for the problem at hand. Sometimes I call this a pluralist constitutional theory, but I think a better term is that it describes the judicial craft as traditionally understood. Now, I'm not going to talk in detail about the components of, or what it looks like to exercise good judicial judgment. I am happy to do that in the conversation. I have a chapter in the book devoted to looking at the opinion, particularly Chief Justice Roberts and Justice Jackson's opinions in the affirmative action case, in terms of how they come out as when examined in light of the idea of judicial craft. But as I say, I'm not going to focus on that now. What I want to focus on for this talk is sort of what should we look for in a judge that will help us figure out whether this person is likely to become my formulation here is a great justice, and maybe a more than average justice in terms of performance. So I start out with a quotation from from Judge Posner from 2016. The date's relevant for people who want inside baseball stories, but I won't give them now. I sometimes ask myself whether the 9 current Supreme Court justices are the 9 best qualified lawyers to be justices. Obviously not. Are they 9 of the best 100? Obviously not. 9 of the best 1,000? I don't think so. 9 of the best 10,000, I'll give them that. Okay? So when a Supreme Court vacancy opens up, a president has a pool of 10,000 people to choose from. And the president's choice is constrained by a variety of political features. So President Obama basically had to choose a Hispanic American to fill the first vacancy that occurred, and he did. President Trump, for political reasons, had to choose somebody acceptable to the Federalist Society when vacancies opened up, and he did. But just to take the Trump example, so there were lists of potential nominees that he had in hand for all 3 of the appointees, and just he chose, and he had his reasons for choosing Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. If he'd faced slightly different political constraints, he might have chosen.
Sorry to interrupt. That mic is just not working very
Oh,
I'm
okay.
going to switch you off to this.
Okay. Sorry.
Everybody had it. It's not your fault. Sorry, everyone. Technical difficulties, not mark-related difficulties.
Okay. So I should just hold on to this.
Okay, I'll take it away.
Sorry.
No, it's
Okay.
not you. Thank you.
Okay, so as I say, he had reasons for choosing the three people he did. Under other political circumstances, with minor differences, he could have chosen Raymond Kethledge, Amal Thapar, or Thomas Hardiman, and basically he would have gotten the same outcome politically and judicially. So, given those constraints, what within the pool that remains, what should we look for? Now, the top-down approach is, well, you look for people who have the right constitutional theory and pick them. I call that a top-down approach. My approach in this chapter that I'm summarizing is a bottom-up approach. It says, look back to history to find out who the great judges were and figure out what made them great, and then look for the same thing in today's nominees. Now, there are two branches here. I'm not sure I'll have time to do both, but one is individual nominees. What qualities have the court's most distinguished members have? And second, the court as a whole. What qualities do strong courts have as compared to weaker ones? So what I did, there are methodological issues with respect to both of those choices. And again, I'm happy to talk about the choices I made. But what I did with respect to the individual justices was to look for surveys of great Supreme Court justices. I found one. Let's see if this one. Yeah, okay. This is a list compiled in 2003. I don't know who did this, but it's consistent with a few later lists that have minor differences. I have some quibbles with this one on methodological grounds. So suppose you take this as a list of great justices. What are the relevant characteristics of these justices that might contribute to making them great? And I say relevant characteristics because this is one obvious characteristic that they're all white men, and that doesn't seem relevant to the things that matter about looking for good judgment. So I have in my files sort of biographical sketches of all 10 of them. It's a very complicated one, and I can't reproduce it in the book or here, but let me sort of summarize the things that are on it. So the first, the justices on the list serve a fairly long time, which means that they're, relatively speaking, youngish, not really young, but youngish when they're appointed. In early 50s is sort of the maybe modal or age. 7 of the 10 are in the top quarter of justices in terms of length of service. Longevity isn't enough to guarantee greatness, of course. James Moore Wayne and John McLean served longer than 5 of the justices' list, and my line is no one's heard of them since they left the court. And I don't know if anybody heard of them while they were on the court. So 3 in the list were in their 40s when they were nominated, 4 were in their 50s, and in good health, which turns out to be relevant later on in my talk. Second is what I call location, and a president had a choice about these characteristics, the age in particular. The second is something the president doesn't have much control over, which is location and political time. Political scientists divide U.S. political history into what I call regimes. In the 20th century, there was the New Deal Great Society regime, and then the Reagan regime. and then, something. And if you look at when these people were appointed, they tend to be people appointed at sort of, I don't know what the right word is, inflection or key points in either the creation or the consolidation of a political regime. Let's see. And indeed, Supreme Court nominees are one way you can push the inflection point or consolidate the regime. Brandeis was an important voice for progressive ideas. Black, Frankfurter, and Douglas were all major figures in the creation of the New Deal regime. Rehnquist became Chief Justice as part of became Chief Justice, not Justice, but Chief Justice as part of the Reagan Revolution. Okay. The third is what I had thought was going to be more important than it turned out to be, which is prior experience in public life. But it turns out that virtually all of them have had experience in public life. And I'm going to come back to that in detail when I look at courts as a whole in a few minutes. The next thing is, I have this in caps in the book, not a judge. It turns out that only three, it's not a small number out of 10, but 3 out of the 10 had whose major work experience before coming to the court was as a judge. But 2 of them were truly exceptional cases. Holmes and Cardozo were the judges for the era before they were appointed. And there's no one now like that available. Posner was until, however you characterize it, until he got too old, I guess is the best way to put it. But there's nobody comparable to him on the scene now. So, if you're looking for the characteristics that go into somebody becoming a great judge, prior judicial experience is not one of the major determinants. And then the final thing I have is intellectual curiosity, which is really hard to measure. And in some ways, I pick up the theme from a political scientist who wrote a book about picking presidential candidates. And so intellectual curiosity, as I say, is hard to measure, but if you sort of look at what these people did, John Marshall wrote a biography of George Washington, which was a history of the early republic. Oliver Wendell Holmes read, everything except social science. Louis Brandeis read social science and probably nothing else. Frankfurter, was a sort of gadfly in the political life of the country. Douglas was an environmentalist. I want to say, this is not to say they were going to be great at these things that they dabbled in, but they were interested in them. And so my thought is, this is one of the taglines, instead of asking what a nominee's judicial philosophy is, maybe we should ask, what's the most interesting recent novel that you've read? I say recent because then, if I say, what's the most interesting novel you've ever read, you can game that. Middlemarch, you come up with Middlemarch, and whether you've read it or not, it doesn't really matter. But if it's a recent novel, you probably do have to have read it to be able to say something coherent about it. Or, in the new world, it would be, what's the best recent movie you've seen? And it would be sort of interesting to hear somebody just say, well, I saw, I did a whatever it is, Barbieheimer weekend, and I liked Barbie and I didn't like Oppenheimer, and here's why. I think that would be revealing about the kind of person that you're getting on the court. Okay, so let's see where So that's for the individual judges. Let's see. Now, next part is the picking a court. When you pick a new Supreme Court justice, you're adjusting the assets in the portfolio. Now, you're not like a manager of financial assets because you can't replace underperforming assets whenever you want, and you can't add new assets that might sort of synergistically improve the portfolio's performance. But I still think you can look at something, look at courts as a whole and get some sense of what contributes to quality in the court. Again, there are methodological issues here, and this what I have here is shot through with subjective judgments. But I started partly because of what I knew about the courts, with a sort of sense that the Hughes Court was a pretty strong court as a whole, that the Warren Court was regarded as a pretty strong court, but it turns out in the first part of the Warren Court, which is the one that is measured here, it was sort of a middling court, and I think it's generally, the Berger Court is generally regarded as a fairly weak court. So then I said, well, what was the portfolio like for these courts? And you can see what the portfolio is. And I think for this one, it's nothing terribly dramatic, except for the substantial public service in elected positions for the Berger Court. Otherwise, people are sort of distributed across the range of prior experiences. And that, okay, so, when you're putting together a court, sort of within the pool of 10,000 and so on, there are lots of options that you can choose. What does strike me is when you look at today's court, and you can see there are three, I think, pretty dramatic differences. First is there's no one on the court who's had substantial public service in an elected position. And there's no one on the court who had substantial experience in private practice, at least non-Supreme Court appellate practice. John Roberts had a significant Supreme Court appellate practice. And there's this, essentially all but one of them had prior experience as a judge. Again, so the disappearance of justices with it, and it's a disappearance. I want to make a point. There used to be judges who had substantial experience as elected officials, including governors of two major states, Hughes for New York and Warren for California, both of whom also ran for president. The disappearance of justices whose primary legal experience was in private practice, and the increasing number whose primary legal experience was as a judge. What sort of inferences might you draw from this? Well, the first one is that two are fairly obvious. One, you might think about a nominee who did have substantial experience in elected office, and a nominee from private practice, including the liberal or conservative public interest bar, with a smaller number of judges. Now, the idea of, I've had the thought that it'd be good to appoint politicians to the court for quite a while. The idea of doing that these days probably sends shivers up the spine. How can a politician think about legal issues with only the law and not politics in mind? I'm not sure that's the right question to ask, but I do want to note that Trump's list, and it now turns out that Vivek Ramaswamy's list of possible nominees does have Republican senators on the list. Trump's had Cotton, Cruz, Hawley, and Mike Lee. Swamy's, I think, has maybe the same four, but a subset of those. The first three are not serious, but Mike Lee, I think, is a plausible conservative nominee. For Democrats, the most obvious name until recently was Jamie Raskin. Other possibilities might be Senator Klobuchar, or my favorite for a variety of reasons, Vice President Harris. Now, when you go through that, there is this one problem. Remember, early in the list is longevity and age. You got to be youngish. And of the names that I've given, to become a significant politician these days, you end up being oldish. Not old, I mean, the name, so Raskin was 61 and 23, Klobuchar 63, Harris 58. And for a variety of reasons, when you go younger, it's harder to find somebody who's a plausible nominee. And there are the examples of Clarence Thomas, who's 43 when nominated, Brett Kavanaugh, also 43, Amy Coney Barrett at 48. The same problem, I think, probably attends finding the nominee from private practice. Trump's list did have Paul Clement on it. By 2025, he'll be 57. It's not clear to me well, there's certainly no one on the progressive side who dominates the progressive public interest bar in the way that Louis Brandeis and Thurgood Marshall did, but perhaps a Democratic president or a Republican one could find. Republicans are constrained against doing this, but could find an unexpected and relatively young public interest lawyer to nominate. My guess is that we're still, because of the political polarization, will still pick too many nominees who are judges. Okay, so I've got maybe 1 minute left. Let me put things together. What markers help us make a decent guess about the possibility that a person about to be nominated for the Supreme Court will turn out to be better than mediocre? Almost definitionally, almost all of them are going to be mediocre. I mean, that's sort of, it's the norm. Mediocrity is just, in virtually every field. For greatness, I've mentioned intellectual curiosity and substantial experience in public life as something other than a judge. For greatness, you have to ask where you are in political time. It turns out that I think a fair number of other people think that we are near an inflection point with some new political regime around the corner, either progressive Democratic or MAGA Republican. For the former, Justice Brown Jackson might be well positioned to become a great justice. As the latter, Justice Coney Barrett. I have a footnote here I want to make clear. I believe that Justice Barrett's association with the People of Praise, which is an association of conservative Catholics, is a plus in the life experience column. I'm happy to talk about why I think that. But the one thing that they lack is the not a judge marker. And maybe we should reconsider that either for political reasons or maybe it's just an artifact of what I've looked at. But why do intellectual curiosity and substantial experience in public life help us make decent guesses about the future with respect to exercising good judgment? Because people with those characteristics have had wide contact with people in many spheres of life, either imaginatively or in person. They've seen people at their best and sometimes at their worst. Now, it's not the case that a person serving as Attorney General or as Governor of California has those contacts daily. Rather, it's that they've done things to get into those positions that gave them such context. So William Rehnquist was an on-the-ground Republican activist in Arizona, and in that capacity, he had to have interacted with all sorts of people. And notably, working as an appellate lawyer in a high-powered law firm doesn't give you those kinds of contacts, nor does working in the White House counsel's office or as a legal functionary in the Department of Justice, which is the some public service list there. I want to say just at the end, modifying the not a judge marker. Trial court judges, particularly trial court judges in state courts, do have the kind of contact with people in all phases of their lives that senators and governors and people, this is a reference to Oliver Wendell Holmes, people deeply shaped by their military experience have. That might bring Justice Brown Jackson back into contention, especially if we treat her relatively brief time as a public defender as relevant. And then finally, again, most important, why does wide contact mean? Because I think it's the best way of learning both what judgment is and how to exercise it. You see people facing all sorts of problems and doing something about them. You think hard about whether they made good or bad choices. And sometimes you have to make similar choices yourself. Wide contact, I think, makes it easier for a judge to exercise good or reasoned judgment. Okay, so that's the first chapter. I'm happy to entertain questions about any part of it or other things that I've alluded to that I'll be dealing with in more detail elsewhere in the book. Thank you.
Q&A. We only have one mic. Sorry, guys. But I'll put it here, and if you want to queue and ask your question, by all means, go for it.
Don't be shy.
Hi, Professor. Thanks for being here. Wonderful lecture. I asked you in advance whether I could ask you this question, and I believe you said yes. You wrote an essay this summer responding to what you called a, quote, not normal Supreme Court and urged the Biden executive branch to adopt popular constitutionalism, encompassing a series of steps up to and including, if necessary, the administration ignoring a ruling by the court and instead have the administration be guided by its own constitutional interpretations, quote unquote. So I'm just curious what prompted this essay. Could you describe the theory of popular constitutionalism, if it differs in any meaningful way from our former Dean Larry Kramer's definition, and whether you think the mood, I suppose, is growing among your colleagues or not towards this very radical and interesting idea that you proffered on the Jack Balkin's blog. Thank you.
Yeah, I'll say a little bit, although it's, full answer would take us really pretty far afield. The idea, first of all, the formulation of acting on, in this instance, the administration's own understanding of the Constitution is actually quite traditional and long-standing. It used to be called departmentalism, and it used to be associated, in the Reagan era, it was associated with the Republican Party, with conservatives, who were saying, look, the Supreme Court has gotten out of control in the liberal direction, and we, the administration, should do whatever we can to offer our alternative constitutional interpretations. And so that's the first point. It's not really, it's an old idea. Second point is that for some aspects of the argument, it should be relatively uncontroversial. That is, take the Student for Fair Admissions decision. The U.S. government doesn't have much direct involvement in affirmative action in higher education, but it does run the service academies. And there's a footnote in the opinion that says we're not saying anything about affirmative action at the service academies. Well, the administration can take the position, and will, there's litigation either pending or about to be filed, that affirmative action in the service academies is okay even after students for fair admissions. And as long as the positions have, depending on your formulations, reasonable or plausible legal foundations, that's also a traditional and I think legally defensible form of opposition to the court. When you work through this, at I think the last stage is what I've called in other writing the Orville-Forbes problem. Orville-Forbes is not exactly the problem, but the crunch time comes when you, the administration, are the subject of a coercive judicial order directing you to do something. And in what I've written earlier, my response is that, or my answer to that problem is, the answer depends on a contingent analysis of whether in some either political, well, mostly political sense, ignoring the coercive order is worth it. So if it was not the case, but if Orville-Forbes had been the subject of a coercive order, my position is he should not have resisted it because it was going to be pointless. He was just going to be overboard by the power of the federal government in the circumstances of the late 1950s. Whether that would be true in the event that the Biden administration were subject of a coercive order, you'd have to look at the circumstances. My guess is that it would be pointless to resist for political reasons, but we wouldn't have to. We don't have to confront that until you know the particulars. So that's sort of. I haven't answered every part of this, but that's the main line.
Hi, Professor. I'm curious about whether your research has any implications for avoiding particularly bad justices being appointed. I'm thinking of, for example, Charles Whitaker, who was noted for not only not being able to do his job, but also for asking justices from the other side to ghostwrite opinions for him. I'm curious if there's any indicators that you can find sort of consistent on that end of even worse than mediocre judging and how to avoid that.
Yeah, so I didn't. I mean, there's partly because although there are lists of great justices they're sort of compatible with each other, there aren't lists of terrible justices that have that have sort of comparable that wash out political disagreement, and so I don't know. At some level, I should look for the characteristics of judicial failures, but it's really hard to know. So, Bushrod Washington turns out to have been quite influential within the Supreme Court. When I was doing my work on the Hughes Court, I came to sort of like and admire Willis Van Devanter, who didn't write very many opinions because he had a legal theory that made it impossible for him to write an opinion. Basically, it wasn't that he was not dumb or bad. It just his theory meant that there was never a stopping point for the analysis. So the answer is that would be a good project, an extension of the approach, but it would be methodologically trickier than this one was.
Thank you.
Hi, Professor. Thank you so much for joining us tonight. So you spoke to how a justice's greatness is dependent on the unique political moment that they're placed in. But I was curious whether you had an opinion as to what degree their greatness is dependent on the composition of the court at the time that they join.
Yeah. So the answer is it probably does depend. So there are two possibilities that come immediately to mind. One is, in a land of small people, somebody whose medium height stands out. And so, if you got a court that is sort of overall pretty weak, somebody who is in other circumstances would be regarded as an okay judge, turns out to be really good for the moment. And the other is that there are synergies, that if your colleagues are pushing you hard, you'll overperform or outperform. I hate the idea of overperformance. My view is there are no such things as overachievers. People achieve what they achieve. But, so let me try to what I'm searching for is somebody who could have been appointed to the Burger Court that would have stood out in a dramatic kind of way in a relatively weak court. I'm not sure I could come up with a name for that to fill that role, I'm trying to think. I'm sorry.
Henry Friendly.
Henry Friendly's probably right. Well, except so maybe the answer to that would be it's all right. His time was during the early Warren Court period, and in some ways, John Harlan filled the Henry Friendly role and did, elevate the court. I do sort of wonder about later, but there probably were lower court judges during the Burger Court period who were age eligible and equivalent to Henry Friendly. I have to look around to see who that might have been, but that would be an example. Yeah.
Thank you.
Hi, Professor touched on it. So your argument enumerates a list of characteristics that you think are relevant to predicting whether a Supreme Court nominee would be a great justice. I was wondering if you think those principles are also applicable to lower court judicial nominees, what the similarities or differences might be with those.
Yeah. So first of all, the pools are much bigger for lower court nominees. Second, as I said towards the end, being appointed to a trial court is a way of gaining the kind of exposure to human experience that makes a judge a great judge. So Justice Kennedy once said, I think here, I heard him say it here at some talk, he was appointed to the Court of Appeals when he was, I think, 39. And he said he was too young to have been appointed to the Court of Appeals. And I think what he was reflecting on was that, he hadn't done enough to be able to have a good sense of what good judging was. Now, maybe I'm not saying he didn't grow into it after time. So that's one thing. It's also so for lower court judges, there's the trial courts. There's a wide range of private practice roles that do put you in contact with people. My view, this is, it's hard for me to distance myself from politics here, but my sense is that public defenders and district attorneys, assistant district attorneys, probably are good candidates for appointment because, again, seeing people. This is a line I think it's from Brian Stevenson, but one thing he says that doing death penalty work does is leads you to understand that people are not the worst thing they've done in their lives. And, people who are exposed to people who are involved, get caught up in the criminal justice system, see, not just they see the offenders, they see the victims, they see the families of the offenders, they see the families of the victims, and it gives them a better sense of the way the world operates than I, as an academic, have.
Thank you.
Hi. I have a question that's somewhat related to the two before me. Watching your presentation, I was struck for the first time thinking about the court as something like the ship of Theseus, where it's like the same court that it's always been, just changing one plank at a time. And I was wondering what you might think of sort of a bigger renovation, what it might look like. I think the obvious place that the mind might go is to court packing or appointing a new group all at once to expand the initial number. But I'm not necessarily asking about that. I guess I'm thinking about any type of proposal that might include bringing more than just a single actor to the court at once. And maybe that would look like actors with different political priors or categories of experiences on your matrix.
Yeah, so here are a couple of things that occur. One would be that just putting aside the political issues and political motivations, one thing that an expansion of the court would do would be to use the portfolio kind of terms, give you a chance to rebalance your portfolio. And so if you thought that you had too many judges, it would give you a chance, people whose prior experience had been exclusively as judges, it would give you a chance to bring in people from private practice or people who had been elected officials. And then you'd be able to see what the impact would be. So again, in sort of rebalancing the portfolio kind of terms, Adrian Mule has this article in the Stanford Law Review saying, maybe we ought to consider appointing people who are not judges, who are not lawyers, to the Supreme Court. And my daughter does IP law, and she reports something that people in many specialized fields report, which is the thing they dread is the Supreme Court taking an IP case. Because they have the justices, they're generalists, it's not a defect, but they don't understand the overall system of intellectual property law. Same is true of tax law. So tax is a little trickier, but maybe appointing somebody from the technology community to the court would be a way of improving its overall performance. I think figuring that out in detail, and Adrian's proposal doesn't quite. You'd have to do some work to make that kind of proposal work, but it would be, given the metaphor of rebalancing the portfolio, I think actually has some bite if you have a chance to do it all at once. It's very hard to do one at a time.
Thank you. I was wondering if when you were doing all this research and analysis, if anything popped out with how former legislators dealt with the work of legislatures and whether they did anything fundamentally differently than people with experience on the bench or elsewhere?
Well, so the answer is, in doing the research, the answer is no. That is, I didn't look at this sort of thing. My intuition is that former legislators and former high executive officials who are not captured by the idea of an overarching constitutional theory, who are pluralists, who are willing to look at a range of things, probably, my intuition is, bring a sense of reality, how things actually work, to the decisional process that would counter some of the influences that more formalist approaches have. I do want to say there is a case for formalism. I don't against this sort of realistic approach. I think the case for formalism is weaker than, doesn't carry the day. But my argument is not, formalist approaches to separation of power are bad because they are formalist. The pragmatic, practical approach, that sort of Justice Breyer-like approach. My position is not that that's good because it's pragmatic and practical. But my overall sense is that on balance, the more having somebody to say, look, when you say the legislative veto is unconstitutional, you don't appreciate the ways in which people in the House and Senate will respond and adapt to accomplish the goals that you think you're saying the legislative veto is going to prohibit, bar from happening. They'll figure out ways to get it to happen. And that might improve the quality of the work. That's my intuition, but I want to say at the outset, I didn't look at that.
Hi, Professor. Thank you for coming to speak with us. You kind of briefly touched upon this on the last question, I think. But what are the sort of like implications that you see with having so many judges that do have prior experience in like courts, and what are your hopes for the ways that you want the courts to change, specifically less so in the political realm and like parties or candidates, but rather in the way decisions are like actively being made?
Yeah. So, I mean, the hope is to get the appointment process to focus more on the quality of judgment that the person has displayed throughout his or her life than on legal theory or constitutional theory. My account is that it's not impossible for someone who has served solely as a judge or almost exclusively as a judge to have compiled a record that shows that this person has good judgment. I do think that our current system is skewed against looking for people like that and skewed in favor of looking for people who are, as I put it, obsessed by theory. So the hope would be, just to expand the pool from which plausible Supreme Court nominees are chosen. That's the base, and lower court judges, but my focus is on the Supreme Court.
Hi, Professor. Thank you. I was curious, you were talking about, the value of life experience, and you sort of contrasted that with the type of experience you get in the Solicitor General's office, and you're trying to put your finger on it, and it sounds like tell me if I'm wrong, it sounds like what you're talking about is empathy, because you're talking about, being close to people making tough decisions and cultivating that. And I'm wondering if that does seem to be what you're trying to put your finger on. And if so, if that points to additional questions we should be asking, not just, let's just take any prosecutor, but maybe we should ask them, what was the toughest case you ever prosecuted? What was the case you regret prosecuting, rather than just tell us about the longest sentence you ever got, because that doesn't really seem like it would be getting at the qualities. And then I also think that would suggest an irony about Justice Jackson's confirmation hearings, where she was lambasted for showing empathy in a CP sentencing, where she showed empathy for both the victims and the defendant and said it's a sad situation for everyone. And it sounds like that goes directly contrary to what we should be looking for.
Yeah, well, so in some sense, yes, I agree. I sort of resist the term empathy because I think it has an overly psychological, I can't get the word out, psychologistic component. And I think what we're looking for is good judgment, which is not divorced from affect, but is different from it. Whereas empathy is sort of too much a term about affect. And in the the discourse that surrounded Justice Sotomayor when she used the term, empathy was taken to mean, I think mistakenly, both as a general matter and with respect to her, sympathy for wrongdoers, trying to understand, the root causes. Empathy is, well, so there's a line in West Side Story about, what is it? I'm bad because I had a bad family situation. That's not the line in West Side Story, but because they're better writers than I am. And that's not what you're looking for. On the other hand, seeing all the ways in which the law affects people's lives for good and bad, that is an important component of good judgment.
I'm curious as to how you see your picking philosophy from the bottom-up approach to affecting the lack of trust and confidence the public has had lost in the court, basically. So,
I guess say that again.
How do you see your bottom-up approach of picking judges? If it was to be created that way, how would that change and hopefully fix the lack of confidence and trust people have in the court currently?
Yeah, okay. So, the phenomenon you're describing has many sources, and no one thing is going to solve it or restore or push the trust level up dramatically. No one thing will do that. Many things together might. One possible, the thought that my approach could help would be that people would see through the nomination process that the people who are being nominated are, I don't want to say just like them, but are, clearly part of the same community of human beings that they are, and not these people who hand down decisions from on high without knowing what life is really like. there's these ads on the radio for Big Lou. He's just like you. That's sort of what you'd get from this. And you know, it's a parody in the ads, and it wouldn't be exactly right in this process, but something like that. At some level, incidentally, that's why I think wartime experience for in the past counted, because you know every male knew somebody who had been involved in, you know, as an active duty soldier. Lots of women too, but and so you know they understood, you know, when Holmes said he was tested by fire, people knew what that meant.
We're out of time. Can we?
We just happened to have run out of questions at exactly the time we ran out of time. So that's the sort of thing you can't plan. But let me just thank Mark for that extremely interesting talk, and please join me in doing that.